We'll call to order this meeting of the Tennessee State Board of Equalization on Monday, October 14, 2024. I'm David Lillard, Vice Chair of the board. And Mr. Pope, would you call the roll of the members?
Yes. Mr. Fleming?
Here.
Commissioner Jaragano?
Here.
Comptroller Mumpower?
Here.
And Treasurer Lillard?
Here.
Treasurer Lillard, you do have an in-person physical quorum.
Okay. All right. We want to be sure and welcome our new board member, Jeff Fleming. Welcome.
Thank you.
And we look forward to your service here. And if there have been any requests for public comment.
Mr. Chairman,
Yes.
can I
Yes.
expand on that welcome?
Okay. All right.
It is a great honor to have Jeff Fleming as a member of this board. It's rare that I'm on a committee where there's an East Tennessee majority, but not just an East Tennessee, but an Upper East Tennessee majority. Jeff is a former longtime city manager of the city of Kingsport, Tennessee. Certainly brings an understanding of property assessments and tax rates and things like that to this. And so very grateful for Governor Lee appointing him to be on this board. Thank you.
Okay. Any other comments or anything? Again, welcome to you. Okay.
Appreciate it.
All right. Do we have any public comments to be made this time, Mr. Pope?
No requests for public comment were received by me before the deadline, which was Thursday by close of business.
Okay.
We did, however, receive a couple requests for oral argument, which you can either hear now or you can hear during agenda item number 9.
Okay. So we'll take those up at the time of the agenda item, I guess. So, all right. Let's see. Let's proceed on here. Then we have the minutes from August 12th, 2024, which are on pages 4 through 15 of your materials. Any comments, questions, or corrections to the minutes?
Move for approval.
I have a motion. Is there a second?
I'll second.
Second. Any discussion? Seeing none, all those members in favor say aye.
Aye.
The opposed, no. The ayes have it, and the matter is approved. Next item is item number 4, review and approval of the assessment designations. Any questions from members of the board on item number 4 here? The designations are set forth in the materials. I'll move approval of that item. Is there a second?
Second.
A second. Any discussion? Seeing none, all in favor signify by saying aye.
Aye.
Those opposed, no. The ayes have it, and the matter is approved. Next item is item number 5, review and certification of the 2023 ad valorem assessments of public utility and common carrier companies. It's presented on pages 16 through 104 of your materials here. Mr. Pope, you want to comment on this or have others comment on this? And I guess the question is we can take these all up simultaneously, I suppose.
That would be my one comment, is that item agenda 5 is actually 3 distinct action items in there. And so 5A, we have Mr. Greg Moody with the Office of City Assessed Properties to present any recommended changes.
Okay.
Hello, I'm Greg Moody. I'm the director for the Office of State Assessed Properties, and we assess 18 different company types of public utilities and transportation companies across the state, and we have our assessments here ready for you to be certified. The recommendations that are coming before you today on a few companies are as a result of amended returns, documentation of companies that have closed, and that's the primary. Thank you. And I'll be glad to answer any questions.
Any questions, Mr. Moody? All right. Thank you very much, Mr. Moody. All right. On number B, referral of matters requiring hearing. Robin, you want to talk about this?
We kept this on here just in the event we did get any sort of last minute requests, but we did not receive any appeals of those OSAP assessments for this 2024 tax year.
Okay. And then we have item C, which is certification.
Item number C is a certification of those assessments as amended under items 5A and subject to any appeals in 5B. There being no appeals, that is before you in terms of a draft resolution adopting those certifications, those assessments for the 2024 tax year.
Okay. Any questions of Mr. Pope of that matter? All right. Seeing none, is there a motion to approve the items under item 5?
Move for approval.
All right. Motions. Is there a second?
I'll second.
Second. Any discussion? Seeing none, all in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. The item is approved. Item number 6, review and approval of revised Greenbelt Manual, shown on pages 105 through 159. There's this minor changes here, I believe, when there, Robin. You want to talk about that?
Correct. The General Assembly recently increased the number of acres that can be included in Greenbelt. And so this manual simply reflects that updated change in our continuing efforts to make sure we stay updated with the changes in the Greenbelt law for that manual.
Okay. Do you have the change presented to you? Any questions about this matter? Chair would move approval of the proposed revision. There's a second. Any discussion? Seeing none, all in favor signify by saying aye. Aye. Those opposed, no. The ayes have it, and the item is approved. Item number 7 is appointment of Taxpayer Agent Regulatory Panel. Mr. Pope, you want to present this item?
The members of our Tennessee Agent Regulatory Panel serve for terms of 2 years. All our currently sitting members have identified their willingness to continue to serve. This is the panel that regulates agents who are registered with the board to represent taxpayers in appeals, regulates their behavior and standards.
Okay, any questions from members of the board of Mr. Pope regarding this matter?
Move approval.
All right, we have a motion for approval. Is there a second?
Second.
All right, we have a second. Any discussion? Seeing none, all members in favor signify by saying aye.
Aye.
Those opposed, no. The ayes have it, and the matter is approved. All right, item number 8 is the next item, review and approval of rules governing public comment at meetings. Mr. Pope, or this is Mr. Childers. Mr. Childers, the staff attorney, will present this here.
Mr. Childers up here with me.
All right.
Good afternoon, Matthew Childers with the State Board. My office has created a new rule to outline the procedure for members of the public to request to provide comments at State Board meetings. This rule was created in direct response to legislation passed last year requiring certain governing bodies to reserve time for the public, comment on matters relevant to the meeting agenda. Our new rule includes basic notice requirements, provides 3 minutes per speaker per agenda item, allows for additional speakers and time if reasonably necessary, and does not impact state or local revenues or affect small businesses. And we previously had our rulemaking hearing to allow for comments about the proposed rule and adopted the one proposed change we received for that hearing. Happy to answer any questions anyone may have.
Chair.
Yes, Mr. Comptroller.
Thank you very much. Just a question for the record. We have been operating under guidelines for some time. And does this differ from the guidelines by which we've been operating under? And if so, how?
No, it doesn't. The only change that I would point to is that our previous proposed rule allowed for 2 minutes per speaker per agenda item. The one requested change we received from a member of the public asked that to be increased to 3 minutes to allow for full discussion and answering of any questions. And in the spirit of that law, we adopted that. So,
Thank you very much. And Mr. Chairman, I think our guidelines work very well. We've expanded the time and move approval of the rules.
All right, we have a motion. Is there a second?
Second.
All right, we have a second. Any discussion on the matter further? All right, seeing none, all those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it, and the item's approved. Thank you, Mr. Childers.
thank you.
Okay, next item is item number 9, review of the petitions for review that are shown on pages 170 to 172 in your materials and other matters. Mr. Pope, you want to present this?
Yes, keeping with our last few meetings, I'll just remind the board members of their options with regards to these appeals. The board has pretty broad discretion of what they would like to do. You can refer review and recommendation to me. You can delegate some or all of the issues involved with the appeal to one or several board members or other individuals you would like to identify. You can delegate that review. You can delegate it review to subject to further adoption by the board, or you can decline review in its entirety, essentially saying no comment on the appeal. And then the parties may pursue their appeal to Chancery Court if they should so wish to do so. I've included a summary on the 3 appeals I can present for the board too, which is a brief or neutral summary of who the parties were and the action in each appeal.
Okay, let's let's take up the first one, okay, and then we'll hear from the appellant on that if it's the willingness of the board to allow 4 minutes or so for argument that's been requested.
All right, we'll do.
All right.
Our first appeal on the list is Wood Lawrenceburg Center LLC versus the Lawrence County Assessor's Office. This appeal was continued from our last meeting where the board asked me to review this case. I did review the entire administrative record and listen to the audio proceeding of the hearing that occurred before Judge Padfield in this proceeding. Essentially, it involves two parcels for the Wood Lawrenceburg Center, which is essentially a shopping center. The judge ultimately found that the appellant, that is Wood Lawrenceburg Center, failed to carry the burden of proof to support a reduction in the taxable value, but did find that based upon a preponderance of the evidence during the hearing, the Lawrence County Assessor's Office did prove the valuations adopted by the local board should be increased, and ultimately the administrative judge increased those assessments slightly, as I noted on page 171, those exact figures in there. I've fully reviewed this case and would be happy to answer any additional questions you have on that.
Okay, is there anyone here for Wood Lawrenceburg Center that wishes to be heard on this matter?
I do see Mr. Burks in the lobby. I know he didn't specifically request to have oral argument, but as well as I believe the county assessor's office has, I think Mr. James was assisting them in their review.
Okay, are there comments by members of the board about this particular case? And everything as Robin pointed out, we've heard this thing previously at a previous meeting and everything is referred to him to review, and he's reviewed it thoroughly. And I assume you have a recommendation, Robin, as to the disposition of this case.
If I were to make a recommendation, it would be a decline exercise review on this appeal.
Mr. Chair, I move we decline further review of the case.
All right, is there a second to that motion?
Second.
All right, we have a second. Any discussion on the matter? Seeing none, all in favor signify by saying aye.
Aye.
Those opposed, no. The ayes have it, and the item is agreed to. Thank you. All right, Robin, next case.
We have two new appeals. Our first being Joseph and Elizabeth Namey versus the Shelby County. For our appellant, we have Mr. Namey, who is present, and I will just go ahead and note that he did request to present oral argument to the board. I can read from our summary. As owners of the subject property, they filed an appeal to the state board following a denial of their application for property tax relief for the 2022 tax year. A hearing before an administrative judge occurred on March 11th, 2024, with an initial decision order issued June 10th, 2024. The administrative judge found that although Mr. Namey mailed his application and check on December 24th, 2022, his application credit voucher, or ACV, was not received by the April 5th, 2023 deadline. The administrative judge found that none of the reasonable cause exceptions permitting a late filed ACV, as in Tennessee Code 675-5-701 subsection K, were applicable. The administrative judge affirmed the denial of tax relief for not meeting the April 5th, 2023 deadline, but noted nothing prevents Mr. Namey from seeking tax relief for any other year. And I know Mr. Namey, as well as the Shelby County Assessor's Office, is on the line, as well as Mr. Sharp from representing tax relief.
Okay. Mr. Namey, we'll hear from you now. If you wish to make remarks in regard to oral argument on this matter, you'll have 4 minutes to make your statement.
Yes, sir. Thank you. Can everyone hear me?
Yes, sir. We have you.
Anyway, I appreciate the opportunity to present oral arguments. I'm sorry I couldn't be there in person. It wouldn't have made a difference. But I don't deny what Secretary Pope has said. My reason for appeal is this. I did everything in my power to comply. I've never missed a filing deadline, never missed paying my taxes. I'm actually the treasurer for the Shelby County GOP here in Shelby County. So I know the importance of getting things done like that. My only reason for appealing to you is that under the letter attached, the email attached from the trustee's office, I never was notified, like other taxpayers, that I was deficient before the April 5th deadline. I would have absolutely cured that. I'm in a position where I'm between a rock and a hard place, and I didn't have a chance to make things right. I'm not trying to deny my taxes. I'm always paying my taxes, but I just, because of this missing mail, either through the USPS or somewhere between now and here in the trustee's office, it got lost. And Mr. Sharp is using a strict cutoff deadline of April the 5th, of which I was afforded no chance to utilize. So that's the essence of what I'm appealing to y'all for tax relief. There's a lot of money involved for me. I'm a retired naval officer, and that's pretty much my situation.
Okay, board members have any questions, Mr. Namey? We'll hear from the assessor's office here in a minute, but any questions, Mr. Namey, at this point? All right, seeing none. Thank you, Mr. Namey.
Yes, sir.
All right, is the assessor's office available and wish to make a statement on the matter?
Good afternoon, everyone. This is Janika White. I am the attorney on behalf of the Shelby County Assessor's Office, and we don't take a position on this matter.
Okay. All right. Okay. So at this point, the board will consider the matter. I've reviewed the record on this matter and read the record on it, and I sympathize with Mr. Namey's statement that he did all he could, in terms of mailing it timely and everything like that, and wasn't given an opportunity to cure, apparently, as he claims other people were. But on the other hand, the burden is on the taxpayer to timely file the request for relief and do so in a manner that makes sure that it gets there, and call and verify it arrived and was filed, et cetera, if necessary, et cetera. So from that standpoint, I just I don't know that I'm in a position to support relief in this case, but that's my own personal opinion. Commissioner.
Thank you, Mr. Chairman. I have maybe an observation or perhaps a question, maybe your direction on how to address it, but about a statute that I don't see being applied in the record.
Mm-hmm.
The assessor in its brief and the ALJ seem to believe that the relief is limited to those provisions set out in 671803C. The statute that gives the DPA, the director, the authority to waive the deadline is 675701K, which incorporates 671803 without designating any particular subsection.
Mm-hmm.
My question is why 671803D would not be an applicable provision, which I haven't seen addressed in the record. And seems to me on its face to address mailings specifically.
Mm-hmm.
It basically states that for delinquencies of less than 30 days, which I believe this is, and when a tax document is mailed and not received, then there is the possibility of relief if the sender, if their noncompliance is explained in 671107. 671107 applies specifically to mailed tax documents. And A2 states that when mailed and not received, it's deemed filed and received on the date mailed if the sender establishes by competent evidence that the document was deposited in the U.S. mail, and the sender files a duplicate within 10 days of notification of non-receipt, both of which seem to be findings of fact in the ALJ's order. So I'm not drawing a conclusion necessarily, but I do have a question as to why that provision would not apply.
Okay, Mr. Pope, do you or the division have any comments on that?
I certainly don't have a comment other than the board has discretion if you would like to remand it for the consideration of those factors. It's within your discretion to do so.
Any other
Chair.
comments?
Mr. Chair.
Comptroller.
And in light of Commissioner Giordano's thoughts, if we were to remand it to the executive secretary for further consideration, would that be at the next regularly scheduled meeting, which will be, I think, in April 2025?
So you have a couple options. You can remand to the administrative judge who made the finding for exploration of those issues raised. You can delegate review to me, subject to final adoption at the next meeting, which would be so sort of two options: actual remand versus delegate to me as executive secretary for adoption at the next meeting, which would be tentatively in April.
Thank you. I'll defer, Commissioner, to you if you have any direction.
I'm not sure about the timing. I was considering perhaps moving for the board to consider asking Mr. Pope to report back to the board on whether or not 671803 D1A is in fact an applicable standard, and does it apply to the facts of this case. I'm not sure about the timing of not meeting again until April. So
Well,
I mean, we could always call a meeting.
yeah, we can always call a meeting if we needed to and everything. One thing that is concerning here is just the precedential aspect of this in terms of, as you said at the start there, reading the statute, Commissioner, that it's established on satisfactory evidence that he did everything he could to mail the notice timely and everything, the document timely and all that. And as you point out, the judge did not seem to take issue with his statement, that he mailed it timely. So he kind of accepted that point and everything. But it is troubling to me that, as in the case of other tax practice I've been involved in, when you mail something that's a document like that, you either got one or two options. You can mail it certified mail, return receipt requested. You've got extraneous proof that it was in fact mailed, or you can call or do other things to verify that it was in fact received timely prior to the deadline. And that whole aspect of it was troubling to me in regard to the precedent that might set for taxpayers in the future. I agree that that's a relief statute that you pointed out there, and in theory, it could have applicability here in this case. So
I do think it's a factor, the reasonableness of the reliance, whether he acted as a reasonably prudent businessman. But I just point out there's a specific provision as to mailings that are placed in the U.S. mail, and it seems to be a stipulated fact that this was placed in the U.S. mail and can be deemed received on that date, as long as he cures it upon becoming notified that it wasn't received.
let me ask Mr. Namey. Mr. Namey, what did you do after you found out that the thing had not been received timely?
Yes, sir. I went down that very day. I got the notice of the full tax bill and gave them a check and filed an appeal, which at the time, according to their general experience, would have been enough in the appeal, but it was denied. But I went down that same day. I got it in the mail that morning, and I said, "Gosh, $4,000 something." So I went straight down there and gave Mr. Kelly Gilmer, who's the supervisor, a check and filled out the application. Did it that same day, which was May the 3rd, which was less than 30 days from April the 5th, which was a strong cutoff, which I didn't know about.
Mr. Chair.
Yes, Mr. Comptroller.
My initial thought coming into the meeting is that it's as you mentioned, very difficult to consider setting a precedent, on the basis of somebody saying, "Well, I put it in the mail and just didn't make it." But however, as the commissioner pointed out, and you, Mr. Chair, this case, because of the actions that have occurred, have a demonstrated history of proof that it appears this did happen, and so perhaps this case needs more thought than the standard case. So I don't necessarily see it as precedent setting, unless some other taxpayer has gone through these same exercises that this one has. So for someone just to come in and say, "Well, I put it in the mail," without any further proof is no standard, right?
All right.
Yeah, I would echo and agree with that. I think one of the things that stood out to me was the fact that everyone involved, it appears to me from the record, both parties and the ALJ all have established that it was put in the mail, and it was actually a finding of fact at the hearing. As opposed to, as the comptroller rightly points out, just someone who says, I put that in the mail and there's nothing to establish that fact.
Well, of course, one option for the board is just simply to accept Mr. Namey's position, and consider the document timely filed, and that's another option at this particular point. And the whole thing, because we send it back to the ALJ, or if we, send it to the ALJ, then he's going to have to conduct a hearing, and take further evidence in the matter and all that. On the other hand, if we send it to the staff, to Robin and to the staff, then they're going to be in a situation where they're not really finders of fact and determiners of law, necessary to make decisions like an ALJ would do, or we would do, in this case. So, in light of Commissioner's comments and the comptroller's comments, I'm prepared to say that from my standpoint, we could accept Mr. Namey's position and deem the document filed timely. I do caution everyone about the situation of that from a presidential standpoint, going forward and everything. So, any thoughts?
I'm hesitant to put the board in a position that it's uncomfortable with vis-a-vis precedents, but I believe from my review of the record that it's established in the facts that the applicable statutes apply. So I would be in favor of,
Okay.
I would be willing to move that we accept that if it is the will of the board, but I don't want to put the board in an awkward position.
All right. Well, if you're making that motion, I'll second that motion.
I'll make that motion.
All right. I'll second that motion.
Mr. Chair.
Yes, Mr. Comptroller.
And again, I point out, and I think we've had a very reasonable discussion here. And again, to me, for the record, as I did just a minute ago, I'll state, I don't feel like we're establishing any sort of precedent with this, short of somebody else having this extraordinary circumstance of having worked their way through the process where there have been multiple findings of fact where no one disagrees. And so, I think that's what brought you here today with your analysis of the law as it was.
Yes.
Okay, we've got a motion and a second on the floor here. Is there any further discussion on that matter? All right, seeing none, all in favor of the motion signify by saying aye. Aye. Those opposed, no. The ayes have it, and the motion is adopted. Thank you, Mr. Namey and the Assessor's Office for your participation today.
Thank you, sir, and thank all of you. God bless you, and I really appreciate this opportunity.
All right, okay. All right, Mr. Pope, next item.
Our last appeal for the day is Greenwise Homes LLC versus the Davidson County Assessor's Office. For the appellant, we have Mr. Charles Walker, who is present, as well as the Davidson County Assessor's Office. Both have requested to present oral argument. Greenwise Homes appealed 9 parcels to the board from the Davidson County Board of Equalization value for tax years 2021. The hearing before the judge occurred on May 16th, 2024, with an initial decision order and corrected initial decision order issued June 27th, 2024. As the party appealing, the burden of proof was on Greenwise Homes LLC to show a preponderance of the evidence a change in the assessed value was warranted. The administrative judge found Greenwise Homes LLC failed to carry the burden of proof to support a reduction in value. Accordingly, the administrative judge upheld the Davidson County Board of Equalization's value determination for all 9 parcels appealed to the board.
Okay. We have the appellant here today to make a statement.
You do, Mr. Walker, if you want to come and make sure we're getting from the microphone so that they can hear you on the record for the folks at home. Stand too. You're welcome to stand at the podium. It's whatever you.
All right, Mr. Walker, welcome. You have 4 minutes.
Welcome. Good afternoon, members of the board. This is an appeal from the findings of the administrative law judge. And what this involved was a lienless pendants, a state lienless pendants that have been filed on those 9 parcels of property. And this particular lienless pendants operated where properties could not be sold, transferred, or mortgaged. So effectively, there was nothing that could be done with the property other than live on the property or rent the property. All of the properties except for one was residential and one of them was office. During that hearing, evidence was presented that the lienless pendens was in effect and that that interpretation given to it was basically correct, and the Court of Appeals had upheld that that lienless pendens would stay on those properties until the case was resolved. Now, subsequently, the case somewhat resolved, and we'll probably won't be in this position next year. But the simple fact is, during this period, properties were not able to be sold. At the hearing, the Davidson County Assessor's Office presented evidence of the comparable value, sales values of other properties. And while we have no dispute that that would be an accurate sales analysis, that's not what those particular properties. And the Davidson County tax assessor who was asked about that testified that they did not consider the lienless pendant. And by statute, they have to consider those legal ramifications. There was no other property that they could identify that could be used as a comparable. And that was my research on it too. I found no other property that was in this position that could be used as a comparable. So I presented the evidence of the actual rent value. And the reason I use the actual rent value is because under that lienless pendens, the court could have terminated the lease at any minute. And traditional leases are not basically, you can't terminate them at will like that. Most people would be in a year lease or 6 lease. So again, there was no comparable rent to use where you're in a lease that would terminate court's will. So those were the values. Those tax records were submitted. No one disputed them. And that's exactly what the value was. So those are the values that we believe the fair market value should be for that year. The property simply not able to be sold or more.
Okay. Questions of Mr. Walker about his statement? Mr. Walker, I'm just having trouble getting to the point of accepting that a lienless pendens filed because of litigation would, as a matter of the law of assessments, change the value, the underlying value of the property, because what we're in effect saying, if we did that, would be that, anytime a lawsuit's been filed and a lien's been filed, then, the property has a much lesser value for tax purposes, et cetera. And that is something that occurs all the time in Tennessee, with respect to various properties and all. And if we accept that as a matter of law, that's not an appropriate principle to me. But
If I could respond to that. Generally, when there's a lienless pendens filed, it would be a dispute over the property. It would most of the time come up with divorce or domestics. So one of the parties would be paying the full value of the property. In this particular case, this had nothing to do with the property. It's a simple claim litigant that has nothing to do with the particular parcel. And there was I would call it an obscure state law that allowed this lienless pendens, which was highly unusual since the actual property that we're talking about here today had nothing to do with that. So I don't know that situation would come up that often. I do think it comes up quite often in domestic situations. But again, both of those parties are going to be paying taxes on it. So if it was worth nothing on one side, it'd be worth it on the other, the person that actually got the. In this particular case, we were prevented from selling it entirely into mortgage. So we received no benefit during the entire year.
Mhm. Guys, anyone have any other questions, Mr. Walker? Thank you, Mr. Walker, for your
Thank you.
argument. We have Mr. Brooke Thompson representing the assessor's office here.
Thank you, Mr. Chairman and members. I don't want to delay this any further. I would just point out the ALJ heard those arguments. The ALJ, I think, kind of echoing what you said, Mr. Chairman, said that for assessment purposes, we have to determine what a willing buyer and a willing seller would do on the assessment date. And the taxpayer has agreed that the property would be valued this way without the lienless pendants, and that any potential buyer or seller would be able to see past the lawsuit as to what the property would actually be worth in an open market transaction. So pending any questions, I'm happy to answer. I would just urge you to affirm what the administrative law judge did.
Any questions, Mr. Thompson, about the assessor's position? Thank you, Mr. Thompson. All right, any discussion on this matter? All right, seeing none. I would move to the board that we decline to hear this case, and assume that's appropriate motion here, Robin. From your
Yes.
standpoint. All right, that we decline to hear this case.
Second.
All right, we have a second. Is there any discussion on that motion? Seeing none. All those in favor of the motion signify by saying aye.
Aye.
Those opposed, no. The ayes have it, and the matter is adopted. All right, further matters to come before the board, Mr. Pope.
Just item number 10, adjournment.
Move to adjourn.
We have a motion to adjourn. Chair will second that. Commissioner Giordano beat me to it. He seconded it first. He's ready to go. All right, all those in favor of adjournment signify by saying aye. Those opposed, no. We're adjourned. Thank you very much.